Assalamualaikum and good day, doctor. My name is Siti Nur Aisyah binti Ramli, with matric number 202032. Today, I will be talking about the copyright issue arise between Sheikh Abdullah Ahmad and University Music and Sendirian Berhad. The subject that will be highlighted in this presentation and part of the case. Fact of the case, plaintiff and defendant, decision of the court, reason for such decision being made, and lastly, our own comments. First and foremost is the party to the case. The plaintiff was a singer Sheikh Abdullah Ahmad. He had been active in the entertainment industry since the 1980. He was given to stage name Datuk Sheikh. The defendant was a company incorporated in Malaysia and was involved in the recording business. Universal Music (M) Sendirian Berhad. While the other parties involved are Music Valley, Malaysian Recording Corporation Sendirian Berhad (MRC), Nawab Production Sendirian Berhad, and Nawab Publishing House Sendirian Berhad. The next section will be fact of the case. The 1983 contract MRC had a contractor relationship with the plaintiff. In 1983, the produce an album named Kau Bungaku. The 2005 agreement Nawab Production, Nawab Publishing House, and Music Valley entered into the sale and purchase agreement whereby Nawab Production withdrawn the album right to Music Valley on a 60 and 40% ownership basis. The defendants, Universal Music (M) Sendirian Berhad, is to pay 40% of the net income to Nawab Production. Next, the 2008 novation agreement was made between Nawab Production, Nawab Publishing House, Music Valley, and the defendants. The payment made by Music Valley to Nawab Production include the liability to pay the royalty on the selling of the album, and the royalty payment for the artist also. The defendant took over the rights and responsibility of Music Valley. However, the plaintiff Datuk Sheikh claimed that he has no knowledge of the 2005 agreement or the 2008 novation agreement.
Hello, my name is Mgm Hao. So next, I want to continue issue arises between Sheikh Abdullah Ahmed and the Universal Music Company. So in January 2005, the plaintiff was told that some of his song was from his album, which had been uploaded by the defendant. Could be downloaded from iTunes at the price of US dollars 4.99. So the plaintiff and the defendant arguments under the control rights. The plaintiff argues that since 1983, 100,000 copies of the album has been sold on the market. As such, the plaintiff is now seeking a 20 royalty from the selling of that song. However, there is no documentary evidence to prove that album sold. The plaintiff is seeking a declaration that has performance rights under the S16A of the CA 1987. As such, the plaintiff now seeks damages for the defendant's breach of the plaintiff performance rights under the S36 of the CA 1987, and that the plaintiff entitled the equitable remuneration under the S60B of the CA 1987. According to the defendant argument, the defendant has charged that subject to the S7 of the 1987 CA, the eligible works for copyrights are as follows. First, literary works. Number 2, musical works. Number 3, artist works. Number 4, films. Number 5, sounds recordings. And number 6, broadcast. Since there is no proof that the plaintiff claimed ownership of the literary, musical or sound recordings of the album Kau Bungaku, the defendant submit that the plaintiff is unable to assert copyrights infringement under the S36(1) of the CA 1987. It is not in doubt. In present case, the Nawab Production company owns the copyrights to the song. That's all my part. Thank you.
My name is Zhou Yino. My metric number is 204508. And now I'm going to present about the decisions of the court and the reason for such decisions. There are in total of 6 decisions made by the court, and I will be explaining one by one. Firstly, the defendant is not liable to pay the plaintiff the 20% royalty from the sale of the album because the defendant was not a party to the plaintiff and MRC. The plaintiff also failed to provide any evidence on the term with MRC in the 1983 contract. Secondly, the plaintiff was only entitled to 8% royalty under 2005 agreement and Novation agreement. In the agreement, the defendant agreed to pay only 40% of net profit to Nawa Production. Therefore, 40% of profits multiplied by 20% of royalties is equal to 8% of royalties in any event. 20% royalty only bind on MRC. The oral evidence of the plaintiff's brother saying Ahmad Nawab, which is the owner of Nawab Production, was present together with the managing director of MRC when he signed the 1983 contract on behalf of the plaintiff was rejected by judge. The plaintiff should have called a witness from Nawab Production to evidence the royalty is 20% if he disputed the figure. That's all my part. Thank you.
Hello, my name is Yugo and my metric number is 20130. I'm going to continue about the decisions of the court and the reason for such decisions. Thirdly, the plaintiff did not take any action since 1983 to sue MRC, Music Valley or Nawab Production, over the royalty payment. Judge considered that if the plaintiff was very serious that he is entitled to 20% royalty, he should have enforced the rights from the very beginning against the MRC. Fourth, the defendant does not breach the plaintiff's right under I-16A. In 1983 contract, the plaintiff controls the album's first distribution, agreed the album distribution by MRC, and to reserve royalties paid by MRC. Again, the MRC did not pay the royalty under the 1983 contract. The defendant does not breach the plaintiff's right because the defendant was not privy to the 1993 contract. Fifth, the defendant does not breach the plaintiff's statutory rights under I-16A. Read with I-36 Copyright Act 1987. The plaintiff cannot claim for infringement of copyright under I-16.3 because Ahmad Nawab and the defendants own the copyright of the album. The plaintiff failed to establish that he was entitled to 20% royalty. Besides, the defendant only need to pay 8% royalty to the plaintiff on behalf of Nawab Production according to the email received by the defendant in 2015 from Nawab Production. A judge allowed the plaintiff's claim in the partial, where the defendant was liable to pay equitable remuneration to the plaintiff because the defendant uploaded the plaintiff's album's songs onto iTunes.
Assalamualaikum, my name is Nik Nurul Wahyu Ayunis binti Tuan Muhammad Rahim and my matric number is 203660. Lastly, based on evidence from iTunes download, the plaintiff royalty only amount to RM247.48. The plaintiff showed that dispute to the copyright tribunal if he was not satisfied with that amount. After analyzing the case between Sheikh Abdullah Ahmad and Universal Music Syndrome Berhad, we have learned that the Copyright Act 1987 under law of Malaysia is a protection given to author, copyright owner, and the performer for their work. The Act defines the nature of copyright eligible work, the scope of protection, and the form in which protection is granted. In the age of the Internet, the conventional definition of copyright has been questioned by information technology. The technology is a platform where we can get the various information in just one click. Hence, many people use the platform as their own good. This will give the benefit like provide the ability to replicate, market, monetize, and listen the world as they see fit. A few of the information that was shared may not have any permission from authority, which are illegal. However, artists should be aware of their right while signing a recording contract or a publishing deal. When artists sign a contract without much consideration, they will end up having unpleasant case scenario and even losing their right. Therefore, artists should learn about how to protect themselves in a negotiation. They deserve to own the art they make. Okay, that's all from us. Thank you.